One of the sad realities in India is that there is a lot of black money in the real estate market. A lot of cash component that is involved whenever you're buying or selling. For this reason, a lot of agreement of sales for a particular property, they are not registered and the stamp duty on that is not paid. Let's say that the true value of the deal is 2 crores and you're only showing 1 crore in the sale deed as the value of the deal because that is the government value. Then for the balance 1 crore, if you enter into an agreement of sale, but the agreement of sale that you enter into with between the parties will show the true amount. So if you show that that is 2 crores and you go ahead and you register the particular document and in the sale deed you say 1 crore, you will get caught. So for this reason, most people don't register the agreement of sale because that shows true numbers. Unfortunately, that is a sad reality in India. And because of this, there are some unique problems that come up. So under Section 49 of the Registration Act, even if an agreement of sale is unregistered, it is still admissible in evidence. It can still be received in evidence. So as the buyer, you can still sue the seller saying that the seller is not coming forward to execute the particular sale deed, and you would show the agreement of sale. Even though it is not registered under Section 49 of the Registration Act under the proviso, it is still admissible because it's a contract suit for specific performance. Now, when you go to court using the unregistered agreement of sale, you face two hurdles. Number one, that it is not registered. And what is the consequence of non-registration? I've made a more detailed video about an agreement of sale and non-registration of agreement of sale, which you can click above to find. The other hurdle that you will face is that of stamp duty. And by stamp duty, I don't mean, the 200 rupee stamp paper that you get. There is a much higher amount of stamp duty that is payable for registration or for when you go for registration and you pay stamp duty for an agreement of sale. So for example, I'll give you the numbers in Telangana. If an agreement of sale is entered into without possession, then the stamp duty payable is 0.5% of the value. So for example, if the value is say 2 crores, then 0.5% is 1 lakh. That is how much is payable for the agreement of sale. And the day you enter into a sale deed, this amount is not adjusted. So this amount is gone. If it is with possession, then you pay 4.5%. But that is adjustable at the time of the sale deed. So given the fact that, people don't want to show the true numbers, number one, and people want to avoid stamp duty, a lot of these agreement of sale documents are not registered and they are not, and the stamp duty is not paid. And invariably, if the seller, if I try to play games with you and you as the buyer, you go to court, although the agreement of sale is admissible in evidence, they will levy a penalty on you for not paying stamp duty at the time of entering into the agreement of sale. Under Section 40 of the Indian Stamp Act, there is a penalty that is payable up to 10 times. So for example, if you had to pay a stamp duty of say 1 lakh, then the collector has the power to levy penalty on you up to 10 times of that, 10x that. So he can levy a penalty upon you for up to 10 lakhs. Importantly, it is important to understand that the 10 times penalty is only on the deficit amount. So if you've not paid at all, then everything is deficit. Now, in such a situation where your case is coming up for marking of documents or when the document is actually the unregistered agreement of sale is being received in evidence and the judge tells you, I'm going to impound this document, I'm going to send it to the collector because stamp duty has not been paid on it. So, go to the collector and represent before him and he has the power to levy 10x penalty on you. Now, does that mean that in every case, the collector has the power to levy the 10 times penalty? So if 1 lakh was payable, on the 2 crore deal, 0.5%, if 1 lakh was payable, does that mean that the collector can automatically levy say 10 times or 10 lakhs penalty on you just because you've not paid? Because the collector has discretion, and discretion we know is a budding ground for corruption and for arbitrariness. So when you go up before the collector and you need to pay stamp duty on the particular agreement of sale, you can make a couple of arguments to say, don't levy 10 times the penalty, levy 2 times, 3 times, 4 times the penalty, but don't levy 10 times the penalty. And here are some arguments that you can make. So the Supreme Court has said that this 10 times penalty can only be levied in extreme cases. It cannot be levied in every single case where there is deficit stamp duty. There are some other things to consider. What is the financial position of that particular person? If that person is not so well off, if he's only a job holder, he's not a big businessman, then the financial position of that particular person has to be considered when levying penalty. The other things to consider is Was the person, did he just not pay the stamp duty, or was there some element of fraud involved? Was there deceit involved? Was he actively trying to rob the government of funds? These are some of the factors, or these are some of the arguments that you can make to reduce the penalty that the collector will levy upon you. Because if you go to court with an unregistered agreement of sale, although it is admissible, you will have to pay a price, and that is the price of the 10x penalty. And 10x penalty is only the ceiling. So it is not that in every case you will have to shell out 10x. The collector has discretion, and these are some of the arguments that you can make to reduce the quantum of the penalty. I hope this video was helpful. Thank you for watching.